Okay, I think we can get started. Good afternoon, and thank you so much for joining the online Minerals to Metals Forum hosted by the Southern African Institute for Mining and Metallurgy. During the discussion, please type your questions in the Q&A section in the toolbox at the bottom of your screen. After the presentations, we will have a Q&A session where you can get the answers to those questions. You may also raise your hand at that point and speak to the panelists directly. Please note that this forum is recorded and will be made available to the public. If you want to remain anonymous, please change your name and leave your questions in the Q&A section. If you have any issues or would like to be added to the mailing list, please send me a private message in the chat. On to today's topic, we have part 1 of the mining industry in Southern Africa, a social and legal perspective on mine workers and health. I am pleased to announce our, oh goodness, I'm losing connection. Can everyone hear me?
I can hear.
Oh, okay, sorry, I just got a little warning and I was worried that no one heard my introduction there. I'm pleased to announce that we have Mr. Vama Jele and Dr. Barry Kistnasamy, sorry if I'm pronouncing that wrong, and Mr. Tladi Marumo. First, we're going to have Mr. Vama Jele, the Executive Secretary of the Swaziland Migrant Mineworkers Association and the Treasurer of the Southern African Miners Association. He worked for the following gold mines: Deelkraal Gold Mine and Leeuwboom. Oh, geez, my Afrikaans is terrible. I'm just going to not even attempt that again to avoid any shame. And now he works with Sibanye Stillwater, worked underground in development ends, the ventilation department, and was offered a full-time bursary by the National Union of Mine Workers to study human resource management and practice. His last appointment was being an acting human resources practitioner at the Kloof Gold Mine. In 2008, he started to work around the region in addressing miners, ex-miners, and their dependence issues. He is currently involved in different leadership levels at country level and regional level. Vama serves as a regional coordinating mechanism executive committee member responsible for the leadership and governance for the Regional Global Fund grant worth more than $22 million. Technical Advisory Committee on Labor Migrant in Swatini, and just to count a few. So I'd like to welcome him to take the platform now. Thank you so much for joining us, Vama.
So much, and I hope you can hear me.
Yes, we can hear you perfectly.
Okay. I will actually talk about the recruitment, especially that normally takes place.
Vama, sorry, we're getting a bit of feedback. Will you mute one of the devices?
Switched off. It was my cell phone.
Oh, okay. Thank you so much.
I will actually talk about when a mine worker is actually recruited from the country of origin to work in the country of destination, which system, which is the recruitment a long time ago, and they keep on changing names as time goes on, because previously this was Bantu, and then it actually native, and then all of a sudden it turned out to be Teba. And then look, coming to that experience, I think it's worth to note that, especially I was July 1988, and I was young and fit, and we left to work at Deelkraal Gold Mine, and the route was very clear. But what matters that I want to put it here forward is that the recruitment process and none of the risks or any information on what you're gonna get or how is the issues around the workplace where you'd be posted to work. And when we went there, the treatment itself by that time was very rude, if I can make it very politely. It was very rude, and most of the miners will remember very well that the
Vama, we're struggling to hear you on our side. Sorry, everyone, just...
You will go through the medical examination, which normally state to the different mining houses where you want to work. But during this process, no information was ever communicated about anything that has to do with mining. And then at the end of the day, we were at the mine and away from places like where people like location, which is away from Begestal, because our place is Begestal or Kutsong. So we were like in a very quiet place in a farm. And we were kept to stay in one room. And I remember very well, it was 20 people in one room. And that time, it was during the time when it was winter. You will just imagine during the winter. To the processing in the mine, we test which you see to it that you are fit to go and work underground. I passed the test. I went to work underground. Yeah, it was a very, very noisy environment and very dangerous, and it was risky work. And should I have been told that mining looked like the way I saw it, I was going to give up immediately. But I kept myself safe and worked for a few months underground. And you will recall that it is also deep mining, where we have 3 kilometers down, and as well as the working hours are very long. We were getting down at 4 and coming back at 4 in the afternoon. And then what matters most is that every Saturday, a number of mine workers do something that we used to say that we clean our lungs, drinking water and vomit it. And then we were told this didn't come from science, but I can say that it was coming from our own African science. And on my return home, it was only the time when I returned with TB, silicosis, asbestosis, and as well as unclaimed benefits. They leave behind their own benefits, like from the pension fund, compensation funds, and as well as other trust funds that have been established from the litigation of some cases. But within this whole setup, I would say that there were a lot of things that most of the time at the country of origin, we were not told about the risks of mining, and as well as what must we anticipate to see in the mining house. And then coming to the recruitment was mostly concentrated on production. Same applies even if you go to, the training concentrates than any other thing. Whether you have to introduce HIV or TB program, into the induction center, it used to attract a bit of maybe 30 minutes only, and then you'll be tested by that time. Was very low. But then they introduce a computer system where we will all do it and we will pass it. But at the end of the day, the information from our services miners was not very clear, and we cannot be able to interpret what we actually learned from the training center. And then that also clouded the exit experiences that of TB unclaimed benefits, because the time when we were employed, we didn't get to know about TB or silicosis, or asbestosis, how do we get that? Even though the occupational health the program in the mine were very strong, but the most was on occupational injuries, that's including as hearing. But wearing the mask was very difficult, taking the conditions that we find normally at the working phase underground. So that is the reason why miners are like asbestosis. So my conclusion, I was so much denial of information to be given to us at the recruitment, and as well as looking at how best that can be addressed. Especially within the training program, if HIV causes asbestos, there was other diseases that are actors or lung impairments. And then coming to end my presentation, I will also touch base on currently the focus is on lung health or lung diseases, whereas when we are understanding the impact of the exposure, we find that some of the miners are suffering from joint injury they got from using the rock drill operation, because the pneumatic drills will always shake his body. The second one is around the skin disorders, especially for miners who have worked for asbestos mine. First experience to see a person was actually found, which is based in Barberton, where the skin has got growing black spots all over the body. And the spot, when you try to bring it, you'll find that it is a growing of asbestos in the body. And there are other diseases which has not been actually taken into consideration, which affects miners because of the environment they've been working into, like the issue of the water that normally they used to get into their boots, which were sweating, and as well as the chemical reaction from the workplaces. So it actually gives some sort of a disease to their return to their home. So all in all, I would say that within the study that we've been working with different partners, at the end, we have been actually reaching out to communities and try to understand the plight of the ex-mine workers, whereby we even interview some of their children, saying that if you could actually go to, you can be offered an opportunity to go to the mine. As you can see your father, will you be able, no way you can go. As I close, I would say that even today, if a miner is suffering from TB or silicosis, he normally get not to enjoy life or to retire, but most of them come back home only to die because of the poor health systems that at most our country of origin do have, because we normally system than the health system. The person have worked for the period of time. We think that it was going to be necessary that we also look at how the policy makers can improve the compensation systems for the mine workers, especially on their return to work, and also the role that can be played by the unions and different stakeholders, and also that whenever full information, genuine information, not the propaganda that used to be given to miners when they were recruited to go and work in the mines. I submit.
Thank you so much, Vama. I'm so sorry about the connection issues we've had, but I am so glad that we've reached out to you and got the perspective.
Hello.
Of what? Hi. Are you? Hello. Oh. I just wanted to close by saying that it's really an insightful story on the plight of the ex-mine worker and what essentially sounds like something worse than war. And I really look forward to part 2, which we can then hopefully have a clearer sense of the, well, at least a clearer connection to really explore that a little bit further. And next I'd like to hand over to Dr. Barry Kistnasamy, sorry about that. He is a medical doctor and the commissioner of the Compensation Commission for Occupational Disease. He also has additional training in public health, occupation, and environmental health. Hi there, Barry, can you hear us? There we go.
Yeah, fine. I hope the screen sharing is working.
Perfect, yes. There we go, yeah.
Okay, well, thanks for inviting me, and greetings to my fellow panelists. And although it was difficult to hear Vama with the difficulties that he's having in a deep rural area, so we do appreciate the personal side. Mine is going to be slightly different, and I'm going to just cover the wider issues of the context of occupational health in the mining sector, the system that collapsed 30 years ago and really did Vama and his colleagues who are still alive, but there's many thousands of mine workers who actually died, have not been part of the beneficiary of services. Just to concentrate on compensation then, and lastly, we'll close with COVID-19, although it's a separate discussion that my colleague will be having about COVID-19 as well and the MQ court case. So the first issue is that there are multiple policy and legal frameworks covering compensation and social protection benefits for workers in South Africa and mine workers in particular. So there's 3 departments involved: employment and labor, mineral resource and energy, and the health department. The further major issue that's affected us is the fact that the South African mining industry in particular, but other large parts of the country, economic sectors are built on migrant labor, or what's called contract labor. And migrant labor is both from within South Africa, euphemistically called labor sending areas, particularly in the Eastern Cape, and also cross-border neighboring countries. So Vama, for example, is from Eswatini and gave you some of his issues as being recruited as a healthy young person. Then we have very fragmented services, so it's very difficult for workers to work and really navigate their path through this complexity of social protection benefits, including compensation services and health services. And lastly, the complexity of multiple stakeholders and role players. So we have a 108-year history of the act that I currently run in the Department of Health. There's, of course, other acts dealing with compensation in the Department of Employment and Labor, and Vama talked about accidents in the workplaces. That's under the Compensation for Occupational Injuries and Diseases Act. And the particular insurance industry dealing with that is the Rand Mutual Assurance, which deals with mine workers' injuries, as opposed to this act, the forerunner to ODIMWA, the Occupational Diseases and Mines and Works Act, which the Miners Thesis Act was set up in 1912. Of course, we do note that gold mining started off many years before that, in about 1887, and diamond mining before that in Kimberley. Unfortunately, in the wake of a leadership role in mining, particularly gold mining, in its wake, the system left a deadly cocktail of HIV, silicosis, and tuberculosis, amongst other diseases like asbestos, coal workers, pneumoconiosis, occupational obstructive airways disease, etc. South Africa currently still has a mineral wealth of 25 trillion Rand in reserves. So that's the mineral wealth in the ground. There's only three things we do not get from the ground. That's oil, bauxite, and we also a water scarce country. But otherwise, virtually every other minerals, including rare minerals, are in South Africa. And at least recently with the gas finds, that's going to help to some energy sufficiency issues as well. And the mining sector plays a major role in the economy. So the system, as I pointed out, collapsed 30 years ago. This act for a long time covered mainly white mine workers. And in 1973, with the Durban strikes and collective bargaining rights extended to black workers, essentially they were brought into the system. During that period in 1973, when the Occupational Diseases and Mines and Works Act, or DIMWA as it's called, came into being, basically you had a system that covered 80,000 white mine workers that are now to be extended to about 1 million workers in general, and basically the system collapsed. So this is the building that we inherited in downtown Johannesburg, where the telephones never worked. So if Vama called, he couldn't get through. This is one room of files. Each file here represents a claim. So we basically did the mine workers, including Vama, a major disservice in terms of the process. And ultimately, many mine workers did not benefit from the compensation payments. And remember, compensation is the last resort. We should go to work to be healthy and well, and ultimately don't get diseases and injuries. But that's for another day and a discussion. Anyway, we reorganized the system, and I'll talk about some of the inputs that we made as we went forward. So this is the legacy issues. We've got about 1.6 million ex-mine workers currently. About probably 50% of them are still alive. And in terms of diseases, this is the disease burden that we currently have. Of course, many of them, if they did not have health services, would not have known from the diseases they have, particularly these chronic diseases like silicosis, asbestos-related diseases, obstructive airways, and pneumoconiosis. So this is the historical legacy over the last 30 years of the disease burden that we had. Did we know? Yes, South Africa hosted the first International Silicosis Conference in 1930. We further had a pneumoconiosis conference in 1959. Of course, this is pale and male. Fortunately, one woman made it into the system in 1959. So it's a very interesting process. This is University of Witwatersrand, outside the Great Hall. And this is the sad legacy that Vama and colleagues, probably just prior to him going through. This is the Witwatersrand Native Labor Association, the forerunner to TEBA, which was the major recruitment agency. And this was a medical assessment for black mine workers as they came through. And when we spoke to colleagues on the sociological side, they said it wasn't about the issue about queuing, but it was the issue around being naked, and where the uncle and the nephew would be in the same queue, the father and the son in the same queue. So really a sad legacy of an industry. I gave you the figures, and just Australia in 2016 had 18 persons with coal workers pneumoconiosis in 1 year. And the Senate committee in the parliament basically went and looked at it. So it just shows how other countries have dealt with mining and occupational lung diseases, very different from the work that we've done in South Africa. Well, anyway, there's a new dawn. So since my taking over as the commissioner in 2012, we moved rapidly to get an electronic system. This is a busy slide, but it brings into account a range of stuff that we're doing in terms of an end-to-end solution that will be IT-based, that moves away from physical records. We've done fairly major issues on tracking and tracing, and we work very closely with Vama Jele and his colleagues in terms of how do we reach out to mine workers that have gone to deep rural areas, and we have some very sophisticated tracking and tracing tools using geocoding and GIS in terms of going into deep rural villages. We've done some registration issues because most of the problems that we've had is that we didn't have a decent database. So we now have an electronic database of 1.6 million records that can also be tracked from IDs, passports, the house that you live in, and GIS located. We started decentralized services starting in Mthatha in April 2014. So previously, a ex-mine worker like Vama would have to come to Johannesburg for a service. And today we've got a series of activities, including the fund that Vama Jele is part of, the Global Fund, where we've opened up these decentralized services. It's not adequate for and creates a lot of stress, but at least we've taken an approach of delivering services to the ex-mine workers, noting that the diseases that they suffer from, silicosis, coal workers, pneumoconiosis, these come 10 to 20 years after the person has essentially left the mines, and you need a system in place actually to detect that with chest x-rays, lung function tests, etc. And I'm going to talk about lung function tests in my closing address. This was a program we ran with Vama in Swaziland. Fortunately, it was a good day, but it was a decentralized service with mobile facilities. This is the unit from Oro Minova, which has got satellite support, as well as issues that we could actually pick up from, with internet access, the electronic database. And this was a vision that we could go forward on. We further went because we discovered that the mine workers needed a bank account. We cannot pay cash. So we took the bank with us to the mobile facility. We're now working on artificial intelligence and computer-assisted diagnostics that can basically, in the field unit, we can actually check whether the person has got a normal X-ray, a tuberculotic X-ray, or some other disease. So we're working at that as well. So what was our success story? Well, we paid out approximately 650 million rand to 26,000 claimants over the last 3 years up to June. You can see in these last figures here for April and May, with the lockdown problems that we've had in South Africa and in Southern Africa, we've reduced the numbers of payments, and approximately, in terms of just in the last year, approximately 3,000 out of the 4,300 were paid to colleagues like in Swaziland, Lesotho, Mozambique, and Botswana. And overall was 26,000 claimants paid. We used to average on average about 2,000 to 3,000 claimants a year. And we've essentially pushed that up quite a bit since the reforms we've introduced over the last 3 years. The area of occupational lung diseases in the mining sector has been very contested. These are the multiple settlements that have taken place in terms of class action settlements. And the most recent one, of course, is the silicosis TB class action. Unfortunately, Mr. Mackay, who led the class action lawsuit, died a week before his judgment in the Constitutional Court, which was a landmark judgment in 2011, which ultimately led to the setting up of the Shia Miso Trust, which is being set up now in terms of disbursement of around 4.2 billion rands in claims and about 850 million for the administration. Unfortunately, the reality of the economics is that it's the sins of the past, where there were stakeholders and shareholders in the past. It's the current shareholders that are being hit by the class action for the problems of 20 to 30 years ago. Let me conclude with 2 or 3 slides. We also discovered as we went up the path on compensation benefits for mining diseases, we discovered that there were other social protection benefits that were owed to mine workers in particular and workers overall. So we discovered there was 42 billion rands in unclaimed benefits. These are pension funds, retirement annuities, funeral benefit policies, and a range of social protection funds that workers did not have. About 4 million workers are owed about 42 billion. And within that framework is about 4 billion that's owed to workers in social protection benefits itself in terms of the process. Let me conclude COVID-19. So unfortunately, COVID-19 is affecting the respiratory system as well. And the worker population we're dealing with is above 60 years of age, and they many times have hypertension, diabetes. So we have to be very careful about how do we do the outreach services going out. So we're looking at some innovative mechanisms to deal with outreach activities as we go forward. We cannot have mass campaigns like you saw in the previous outreach campaigns. So it's going to be a very limited setting with about 10 workers at a time, you know, coming in and being seated with social distancing. We're still very worried about getting them out of their homes. Definitely, we will not be doing lung function tests. So we're looking at a new process in terms of impairment criteria. And we're doing some major research work now about how can we actually look at age, years of work experience, the jobs that the colleagues did, and trying to get hold of the dust levels, which Vama talked a bit about in terms of the dangers that he didn't know as a young mine worker when he first came to the mines, that this was such a hazardous area of work in terms of working at it. So we could not deliver this without bringing together a compact, the new dawn as we call it, with the Minerals Council, the former Chamber of Mines, members of the Gold Working Group, trade unions, etc., and working very closely with Vama's, the ex-mine workers associations, neighboring country governments, and a range of social partners. Well, we hope that 100 years from now, we would not be able to quote Sol Plaatje, who talks about in 1912, the African National Congress, as the ruling party in South Africa was founded, the same year that my act that I currently run has been involved. And in 1914, Sol Plaatje writes about the fact that 200,000 subterranean heroes underground who by day and by night for a mere pittance lay down their lives to the familiar fall of rock and were deep levels ranging from 1,000 to 3,000 feet in the bowels of the earth, sacrificed their lungs to the rock dust which develops meningitis and pneumonia. So less history treats us harshly that we knew about this problem and we did very little about it. And hopefully as we go forward, that we will intervene in terms of healthy workers that come to work on a daily basis, fit for tomorrow and fit for life. Thanks, Chair, and back to you.
Thank you so much. It's good to know that we have pioneers at the forefront trying to address this incredibly entrenched, dehumanizing industry. So thank you. Without further ado, let me hand over to Mr. Marumo, a Doctor of Judicial Science candidate at the University of Notre Dame. His doctoral research undertakes a comparative analysis of the South African gold mining industry, silicosis and tuberculosis mass personal injury class action litigation, and the United States mass tort law class action litigation. I'd like to hand over to you, Marumo. Thank you.
Thank you very much, Aysha, and good afternoon to everyone in South Africa. And to some people I know who are here in the United States, good morning to them. My discussion, thank you very much to the panelists as well for setting the foundation for my discussion, which really touches on the legal aspects. So thank you very much to Vama and Barry. My discussion today is really going to be focusing on one judgment handed down by the Labour Court recently on the 1st of May, 2020. And I don't want to go too much into the class action aspects at this point, which I would like to save for the second part of our discussion. So having laid that out, I then want to begin. What the recent COVID pandemic has really done is it's undoubtedly redefined the world as we know it. It's no longer life or political governance or business as we know it. Governments really around the world are urgently responding to the exigencies of an unprecedented and novel common threat. And in so doing, they suspend certain civil liberties under arguably legitimate or illegitimate means of disaster management. So courts then, as we have seen really around the world, in recent times have emerged during this pandemic as forums for legal contestation. And if one were to summarize what really the legal contestation is over, it's really over one central democratic element, and that is consultation between governments and the citizenry. So with that, this judgment, the Association of Mine Workers and Construction Union versus Minister of Mineral Resources and Energy then comes into focus. So as a brief summary, consequent to the COVID-19 pandemic affecting South Africa, on March 15, 2020, the government declared a national state of disaster in terms of the Disaster Management Act. And so a range of methods to try and mitigate the impact of the pandemic were then undertaken in various sectors and in various industries, but also in our private lives. The Association of Mine Workers, or AMCU, as it is commonly referred, filed an application in the Labour Court, and they relied on the Promotion of Administrative Justice Act, or what we call the PAJA Act in South Africa. What is really at the heart of the litigation was the contention that the Chief Inspector of Mines' decision not to invoke Section 9 of the Mine Health and Safety Act failed to meet the test of reasonableness standard required by the Constitution and given effect to by PAJA. So essentially, the contention that AMCU was making was the measures that the department and the Chief Inspector of Mines took were inadequate. They were inadequate to ensure that mine workers return safely to their working environments after the national lockdown that was declared. But also interestingly, these measures also were inadequate in ensuring that the mining communities in which these mine workers resided and came from and would return to were safe. So I just want to set up the framework that defined the court's investigation of this matter and also the reasoning of the court. So in terms of PAJA, the legislation, the act, when the state or an organ of state makes a decision, the decision can be reviewed in terms of the legislation. So essentially what the reviewing body or the court in this instance would look at is, what was the nature of the decision? What is the identity and the expertise of the decision maker? What were the range of the factors that were considered by the department? The reasons given for the decision, the nature of the competing interests involved, and the impact really of this decision on the lives and well-being of those affected. So the union's argument was the department failed to use various regulatory measures at its disposal, which would include declaring COVID-19 a health hazard under the Mine Health and Safety Act. And in so doing, require mining companies or employers in the mining industry to formulate a code of procedure, a code of practice rather, abbreviated as COP, as I will use the term. So the purpose of this application in essence was really to have the decision by the Chief Inspector of Mines not to enact guidelines in terms of the Mine Health and Safety Act requiring employers in the mining industry to prepare a mandatory code of practice reviewed and set aside. So the relief that they sought was for the department to establish a detailed national standard to protect health and safety through legally binding obligations. This was as opposed to the then existing very broad regulatory measures and voluntary measures that, that the industry was undertaking at the time. So really at the heart was the need for legal enforcement. The department had to take steps to require the employers in the mining industry to actually take legally enforceable steps to protect mine workers and also mining communities. So in summary, this is what the Department of Mineral Resources and Energy's argument and response was. So while the DMRE minister and the Chief Inspector of Mines agreed that there was a need for urgent, detailed, binding national standards, they disagreed with the union on two central aspects. They disagreed on the statutory mechanism to be employed to achieve this purpose. And they also challenged the alleged unreasonableness of the decision not to invoke the Mine Health and Safety Act. And so consequently, the DMRE minister and the chief inspector of mines opposed the relief sought by the union on the following two grounds. They submitted that the pandemic is a public health matter rather than an occupational health issue, and that it should rather remain regulated by the Disaster Management Act. And what the government, the department, and the chief inspector of mines also argued was that the union was unable to establish that in the absence of a mandatory code of practice being required, employers in the mining industry would not act at all. They furthermore argued that the union's claim fails to acknowledge the very diverse circumstances of the individual mines. And also that the existing regime, which allowed for a standard operating procedure to be adopted by mining companies. And I'll get to the difference between a standard operating procedure and a code of practice in the course of my discussion. So in essence, the Mine Health and Safety Act does enable the department to declare certain hazard, certain condition or certain illness as a hazard, and thereby require that the employers take legally binding steps in the form of the formulation of codes of practice in accordance with the guidance that the minister would then issue. So in essence, the court really was trying to balance various things. It was trying to balance the interests of the mine workers and the community, but also the economic interests. The mining industry had to undergo various shutdowns, various mines closed, and this of course had a devastating economic impact. But what is really interesting, and I just want to highlight the salient aspects of this case without spending too much time, was the following. The court highlighted the vulnerability of mine workers. And so what the court did is that it foregrounded the fact that mine workers are particularly vulnerable to serious illness or death from the COVID-19 pandemic for two reasons. Mine workers already work in confined spaces where it is impossible for social distancing, but also mine workers are widely affected by pre-existing diseases as my panelists have already spoken about: lung diseases, silicosis, tuberculosis, pneumoconiosis, but also HIV and AIDS. So the court already showed that mine workers were already vulnerable and that the pandemic would essentially render them even more vulnerable. But also what is quite interesting in our jurisprudence in South African law is how the focus is now moving not only onto mine workers, but onto the communities. And I really think this is very interesting about this case. We have seen in terms of the regulatory law related to mining rights and mining rights applications, one thinks of the Bengwenyama case, one thinks of the Maledu case as well, where the Constitutional Court has in recent times spoken about the need to consult with mining communities before mining operations are undertaken. But what is really interesting here about the case, this particular case, is that it foregrounds mine health and safety in respect of mining communities. So the court then summarized really two important aspects. It said that while this pandemic is new, the risk of infection to mining communities is not new. As Barry has already spoken, there has been a range of litigation. One thinks here of the Cape PLC case, which was a litigation brought in the United Kingdom in the early 2000s by asbestos mine workers against a asbestos mining parent company, not only by mine workers, but also by the community for environmental exposure. The same occurred with the South African version of that same litigation, which is called the GenCore class action. So communities who were environmentally affected could then pursue mining companies for exposure. But what is really interesting here is that we're not dealing with environmental exposure. We are dealing with the infection and contraction of a pandemic by transmission from mine workers to their communities. And that really highlights the responsibility of mining companies that goes beyond. So the court really looked at this argument that was made by the department that public health and occupational health were different. It really found that this dichotomy between public health and occupational health in the mining industry is a false dichotomy. The court found that there really isn't much of a distinction anymore between public health and occupational health when it comes to a pandemic, particularly such as COVID-19. And so the court looked at medical evidence and a range of factors. But what is really interesting is how the court focused its attention on the definition of public health versus occupational health. It stated that public health concerns the entire population and occupational health is a subset of that population. My emphasis here is how it defined occupational health to include, and I quote, concern with the health of not only workers in their specific geographic workplaces, but also persons or populations affected directly or indirectly by mining operations in a particular work site or across a particular industry. So you will agree that this definition really is much broader. Barry spoke about how previously we referred to areas such as the Eastern Cape as labor-sending areas. So these were areas where mine workers, as Vama spoke about, were recruited from and sent to work on the mines. And we often have thought of mining communities as communities surrounding the mine. So, but what this definition that the court has now adopted is really no longer making the distinction between a labor-sending area and an immediate geographical mining community. It places them together. So the obligation on mining companies seems to now extend beyond, because the court said these areas are not only in South Africa, but also in the neighboring Southern African areas. So mining communities, the definition has now been broadened. So the court has really now redefined how we think of this. So going back to my distinction between an SOP and a COP, a standard operating procedure is essentially relatively voluntary. It is not mandatory. Mining companies tend to do this in their day-to-day work to ensure health and safety, but the court highlighted the limitations of what was currently being implemented. An SOP does not provide for a time limit for implementation. It does not provide for a mechanism of interim protection. It also does not provide for review by the Chief Inspector of Mines. And it also does not provide for a compliance mechanism. So in contrast then to a mandatory code of procedure, which is what AMCU, the union, had sought the department to implement, was a single national standard in the form of guidelines issued by the Chief Inspector of Mines. A standard set which would be arrived at after consultation with employee representatives. But also it applies a review by the Chief Inspector of Mines. It enables for the employer itself to review the COP if it does not comply with the guidelines. So what the court found is that a COP compared to an SOP really provides for a flexible method that allows both the mining company to be specific to its operations, but also while adhering to mandatory guidelines in that regard. So just to conclude then, the court found in the favor of the union and held that the minister should publish guidelines by no later than May 11, 2020. These were then subsequently published after significant consultations with various stakeholders, including AMCU in the mining industry. But just to end off, what is really interesting is also to look at a comparative analysis, just briefly. I find that the South African approach, which is a mandatory approach, is a much more enhanced, a much more effective one. And when one looks at the comparative analysis in countries such as Australia, it's quite interesting to see that there are certain similarities. In Australia, in very brief summary, the industry, the mining industry, in light of the pandemic, has focused on communities and has also extended the definition of communities as well. in this particular context, the indigenous people of Australia, or the Aboriginal people as they are commonly known as, constitute 3% of the country's 24.6 million population. But what has occurred is that a lot of the Aboriginal people work on the mines. And so the mining communities from which they come, which are predominantly rural, have low employment rates, poor housing, render them vulnerable. And what has been found by reports is that these communities have a 10% lower expectancy rate. So in dealing with the mining industry and the pandemic in Australia, what has occurred, the governments and the various territories or states in Australia have limited travel across these regions. But also in the working on the mines, the Aboriginal employees on the mines have also been separated, particularly because they are, from a health perspective, more vulnerable. So the focus on communities and the protection beyond the mine is not necessarily novel to South Africa. It is a focus around the world as well. What we find then in the United States, which is quite interesting, is the US approach in their Department of Labor and their Mine Safety and Health Administration does not follow a mandatory approach. So the legislation and the administration follows the president's guidelines dealing with the virus, but also it follows the Center for Disease Control and Prevention and the interim guidance for risk assessment and public health management of persons with potential coronavirus diseases. So while it is not as mandatory as the South African approach, there is a similarity. What I find in the US is that the inspectorate is monitoring quite closely compliance by the industry with regards to the pandemic. So in conclusion, ladies and gentlemen, I have not gone into the class action discussion, but I just want to leave it there. And just to highlight the fact that what is happening in the mining industry is the need for urgent measures to be taken and the legal mechanisms to ensure compliance across the board, while at the same time allowing for flexibility unique to the circumstances of mining operations. Thank you.
Thank you so much. It's quite fascinating, and I'm from a legal background, so it's quite interesting to see that mining communities, how much it's been redefined and how that's going to lead into more interregional discussion on a lot of these health issues, and it would be really fascinating to see where this goes. I'd like to invite Vuyokazi to join us. We just want to address the panel directly with some of the questions that they've had on the
Yes.
There we go.
Yeah. I have very touchy concerns. My question is to the gentleman who just presented. And my question, I have two questions actually. Has there been okay, from what I'm hearing from you, there was a court case and then the union won, right? Has there been somebody who is independent that has been appointed by government, the DMR, and the Chamber of Mines, and the unions, who is going to be doing monitoring of the number of COVID people affected and reporting, and that person not being? That is question number one. Mm-hmm. Question number two, if it is being said now, it is safe for people to go underground. Let's take a operates from 4 a.m. up until 9 a.m. And during that time, it takes plus minus, let's say 15,000 people or 5,000 people. How has now the schedules changed? Is there some proof that says, okay, because now we have this pandemic, instead of the going for 3 hours, whereby on each, for example, if it's 4 shafts, it carries maybe 60 people. right? Has there been a schedule that both the unions, the DMR and the minister have agreed on to say, okay, now, even with the engineers, this is the schedule that we have, so that compliance for people going is monitored. Thirdly, the mine hospitals, they do not have the capacity to hold the number of people that are affected. In terms of mine health and safety now, has the Department of Health ensured that there is capacity, or mines are forced to capacitate their hospitals? If it now means one hospital or 3 hospitals have to be built, has those measures been taken? Because when it comes to COVID with mine workers, I hear the argument that there are also other illnesses, and now COVID is being made to be separate. But the issue is the pandemic, it's a pandemic. I'm not taking down the rate of silicosis, but now if one person at a shaft is infected, actually, that person has the propensity to infect what? Plus minus 59 people, because that person spends his time frame with 60 people on the shaft going down, and then when that person goes to the panel, there are 15 people. So at 59 plus the 14 people he is going to interact with. So what has the government, the unions, and the minister have done to ensure that besides production, the safety of the people is being taken into consideration?
Thank you very much, Vyokazi, and I find your questions are very important, very, very important and compelling questions. I will do my best to answer that. As an outsider, my colleague Barry is much more involved in the conversation aspect. But on your first question, with regards to an independent person who has to then, sort of do the work and perform a monitoring role, there is not. The obligation is on the Department of Mineral Resources and Energy and the inspectorate and the mining inspectorate to perform that role. They are the ones who inspect the mines to observe whether there is compliance with the Mine Health and Safety Act, and also now the mandatory guidelines that have been published for the formulation of code of practices. So while I do lament the fact that we somehow feel the need to have independent persons to even monitor the work of government, it is quite unfortunate, because the role of specific departments is to perform that. So, the answer to your first question is no, there is not an independent person. And from a legal point of view, in terms of the Mine Health and Safety Act, the Department of Mineral Resources and Energy has to perform that role. And unfortunately, taking the government to court, which we see a lot around the world now, particularly in these times, is a method through which people or organizations are holding government accountable for its action or inaction in dealing with this pandemic. So I would agree that there needs to be an oversight role to see whether the work is being done. But unfortunately, the independent body in terms of our constitutional democratic system is the courts, as this case really shows. Your second question asks about the measures that have been taken by the industry. The guidelines on the code of practice, which unfortunately due to time I was not able to get into now, but I will definitely do so in the second part of our discussion, sets out a range of measures that have to be taken. So in summary, medical screening, methods of social distancing, reporting of cases, setting out a program on how to deal with this unique to a specific mining operation, a range of factors, risk assessments that have to be taken, medical surveillance that has to be undertaken, monitoring, and the list goes on. And I will get into greater depth with this. Those measures are set out in great detail in the guidelines for the formulation of the COP. However, as you and I know, the question is whether will there be compliance? And again, it takes me back to the point I made with relation to your first question. This is where the inspectorate needs to ensure that the industry is complying. And unfortunately, if it is found that the department is not performing its inspectorate work, it will find itself again in court. Unfortunately, we know the legal processes in South Africa and how cumbersome they can be. So the measures are there. The question is, are they now being complied with? With regards to capacity, the employers in the industry have to create the capacity within reasonable measure. They don't have a choice. It is part of their legal obligation. And this is really at the heart of what the union in this case was arguing, to say, if we're going to make these measures voluntary and use a standard operating procedure and legally unenforceable measures, what are the chances that there will be widespread compliance by the entire industry? Of course, we know that there are cases where some of the mining companies have gone far and beyond voluntary measures and have really been implementing and creating capacity in this regard. But unfortunately, there are also those who don't. So the capacity has to be created. And now that it's a legal method, now that the Mine Health and Safety Act, in terms of Section 9.3, has now come into force and the guidelines have been issued, the industry has to create the capacity.
Hi. So we've gone over time slightly, but we have one more question that I think, Tladi, if you don't mind, I think it will relate to you as well. So the key question is, who is responsible for the burden of truth and on whose cost? Taking into account that the compensation process is not an easy mechanical process. This is related to the agreement that yes, COVID-19 exacerbates pre-existing mining, related occupational respiratory diseases. So yeah, who is responsible and at whose cost?
Thank you very much, Aysha. And that is also a very good question. Thank you for that question as well. And now that we've defined COVID-19 as an occupational health disease in terms of the Mine Health and Safety Act, and what now happens is that it triggers all the legal and compensatory processes. Essentially what that means is that my fellow panelist Barry will be very busy. So in terms of the Occupational Diseases and Mines and Works Act, which establishes a compensation fund, the employers contribute through levies based on the number of employees and the kind of operations that they have to the fund. And when there is a compensable disease, then you claim from the fund. What is really interesting as well now in light of the Ngala class action, and I will speak to this point when I get into the class action discussion in part 2 of our panel discussion, is if the mining companies are now found to have been negligent, so negligent in their failure to adhere to the legal requirements in terms of the legislation, but also in terms of the common law, and by common law, I mean delictual liability. If they are found to have failed to foresee, but also to put in place preventability measures, that negligence could open them up to a civil claim or a class action, as we've seen with the Ngala class action, over and above the compensation. So the liability then lies with both with both the inspectorate to ensure that there is compliance. And if there's not compliance by the employers, then they could be subject to administrative fine in terms of the Mine Health and Safety Act. But employers could also then be found to have been civilly liable. And my colleague Barry could also find himself settled with several compensation claims.
Thank you so much for that answer. And we will be closing the session. This is part 1 of the 2-part series. Part 2 takes the context that's been established here to consider the efforts of putting class actions into practice, as Tladi has just mentioned. So, has there been effective distribution of wealth post-class action? How could we avoid history repeating itself in the current COVID-19 crisis? All of these issues will be discussed in part 2. Thank you so much for joining us for part 1, and we will see you next week, same time, same place. Thank you, everyone.